thanks for being here. We're excited to put on this claims fundamental training this year. By the end of today, you're going to know everything that you need to know for claims, but you don't need to memorize it because we are here anytime you call to help you with all of your claims. So let's see, that's me. Here's just a general overview of IRMA. We are your full service risk management partner. And so this is our organizational chart. We have 70 municipalities that are members of IRMA right now, and each municipality has a seat on our board of directors. Our board of directors meets quarterly, and so 4 times a year we have a board meeting, and like Jenny said, our next board meeting is October 16th. Our board and all of our members, so you own IRMA, and so our members make all of the decisions for IRMA's governance. So our budget, all of our coverage issues and things like that. Our governance structure, you can see that underneath the board of directors we have an executive board, and then we have 4 standing committees as well as 4 steering committees. So the steering committees are subject matter experts, your fire chiefs, police chiefs, public works, and then parks and rec. I encourage all of you to get involved in this. We will be soliciting volunteers to serve on all of our committees at the October meeting, and then they will be selected for the December meeting. So your delegates and your alternates will get a letter asking for you to volunteer, so let them know that you're interested in participating in any of our committees, and the committees meet quarterly, so it's not too burdensome to come to a meeting 4 times a year. We have then our staff. IRMA has 20 employees, and our longevity among employees in tenure averages about 11-12 years, but the experience is probably 30 years. So we have really a lot of subject matter expertise at IRMA, which is why we are here to help you and partner with you in handling claims. Now, in addition to claims, what you see is, we provide trainings. Next year, we're going to provide about 50 special trainings. This is one of our trainings for this year. So I encourage you to look at the trainings that are offered and attend them, and also share the information with your colleagues at work if there's trainings that you think that some of your colleagues would benefit from. We also, on our website, we have just a tremendous amount of online resources. We have model policies, any policy that you're looking for, we have on there. We have grant programs also that everybody should be aware of. For 2018, we're going to be rolling out 3 new grant programs. So what we do there is we know that municipalities have financial constraints with budgetary issues, and that sometimes safety equipment or safety purchases is low on the priority list. So what we do is we have grant programs to try to help encourage your municipalities to support the expenditures that really are ultimately aimed at reducing losses and reducing claims, which is what our ultimate goal is. We also have a lot of pricing discounts. Since we can't have grant programs for everything, we've negotiated a lot of discounts for different safety equipment, like ballistic vests, like certain safety equipment for public works, for example. We have a lot of discounts that are available just to IRMA members that we've negotiated with various companies. I also want you to be aware of our early intervention program. So you don't have to wait for a claim to call us. Our early intervention program is really aimed at preventing claims before they happen. So what circumstance would that be? It's oftentimes with employment issues. So everybody has a lot of municipalities' work is dealing with employment issues, since it's all service, right? So we are people and we serve. So when you have employment issues, rather than if you believe that there's some potential exposure, give us a call. We've got attorneys who can help to make sure that you've documented the situation well, to be able to at least, if not prevent a claim, then mitigate the claim when it does come in by preserving the evidence and making sure that appropriate documentation has been made. We also have another example of just early intervention. Sometimes your village boards will make a decision that might cause a lawsuit, and you can anticipate that. You can see it potentially coming. You know what? Give us a call. We can help to guide your board to understand the implications of decisions by a village board that could result in lawsuits. So give us a call anytime that you have concerns about a situation, and we're here to help. You know, another example is when you have a serious workers' compensation injury. We have a rapid response team that will come out to your municipality that same day when you have a really serious injury. It's a very stressful time, and we're there to make sure you're getting the statements that you should be getting, that you're prepared for OSHA if OSHA needs to be notified, and handling with OSHA. So that's what we're here for, and just remember that when those situations occur, give us a call and we'll be there to help. So today you're really going to talk about claims, and that is our core business, is really handling your claims. So we're the subject matter experts on that. We provide all of you with full coverage on all lines. And so what you'll see on this chart is all the different lines of coverage that you have. And you know, primarily the way that we view it is there's workers' compensation and there's GL. And under GL there's various lines that Keena and Patty are going to talk about today. You'll see on this chart that 70% of our costs, and so this chart shows you what our costs are, and the next one's going to show you the number of claims, but it's really in workers' compensation. And for those of you who have handled workers' compensation cases, you understand why that is. Those cases tend to be very costly, both for medical and for the time off, and even outside of the IRMA cost, you know that because of the vacancy and the absence, that you're incurring the overtime and the remaining staff is burdened. So we work really closely with you with one goal in mind: get the injured worker back to work as soon as possible. It's undisputed that the longer that an injured worker is not working, the more likely it is that they're not coming back. And those career-ending injuries are the most costly, not only because of the workers' comp costs, but there's also a lot of other costs with public safety that you may get a chance to talk about today. So here's the claims experience, or the frequency as well. You can see that again, workers' compensation is our highest number of claims. I'm going to take a minute to introduce our presenters and then our staff that are here today. So the presenters today for the workers' compensation segment is Mike Metzger, which is our supervisor for the workers' comp team, and Melissa Hurd, who is our workers' comp adjuster and handles a lot of our complex claims. We also have Keena Marks Cutler, who is our GL supervisor, and Patty Nowak, who is our GL claim adjuster. So these are going to be your presenters today. In addition, in the audience, we have a lot of our claims staff here, so if you have an opportunity on a break to talk to any of our adjusters about particular claims that they're handling for you, please do so. I know that most of the time it's just a voice, so let's put a face with the voice, and we'll start with our workers' compensation team, which is Sheila Klimzek. She can stand up. Sheila, give a little wave. We got Dorothy Muha next to her. And then Jill Menunez, who handles mostly our subrogation claims. And then Rose Hayden has our medical-only claims. And then on the GL side, we have Colleen Rhodes over there. Hi, Colleen. Faith Stiles. And Faith does a lot of the subrogation as well. And Colleen does our GL claims. Margie's not here?
On vacation.
Oh, she's on vacation. Oh my gosh, we let her go? Oh, she's settlement conferences, of course. We don't let anybody take vacation. All right, so welcome. I hope you enjoy the presentation today, and I'm gonna go ahead and have Mike come on up here, right? Oh, Melissa's coming up, okay.
Good morning. My name is Melissa Hurd, and I am the Senior Work Comp Claims Adjuster, and thank you for joining us today. So we're gonna start with the particulars of the law regarding workers' compensation. There has to be an accident and an injury to file a claim. The accident has to arise out of and in the course of employment. AOE, arising out of, and COE, in the course of employment. The Illinois Workers' Compensation System is state-ran. There are jurisdictional differences, and the work comp laws vary from state to state. Work comp is exclusive remedy. The claims must go through the Illinois Workers' Compensation System, and the benefits provided are the sole remedy. The injured worker cannot file a workers' compensation claim and a liability claim against their employer. There are statute of limitations involved with workers' compensation. An injured worker has 45 days in which to report an accident and an injury to their employer. Oftentimes we get calls from the member indicating that they want to deny the case because the injured worker waited days or even weeks to report the injury. Although that's a red flag, late reporting is a red flag, that is not a basis for IRMA to deny the case if they report the injury within the 45 days. There's a statute of limitations, which is 3 years from the date of injury or 2 years from the last date of compensation. And compensation can be defined as the last date of a TTD payment or the last date that a medical bill was paid. So you keep that in mind. We're going to, during this presentation, Mike and I will cover the following topics, and this will essentially take you from the beginning to the end of a claim. Report of injury, completing forms, the investigation, compensability, treatment and benefits, and claim resolution. Medical-only claims. Medical-only claims are where there is no lost time from work, or if the injured worker has missed less than 3 scheduled shifts. So if they are off work and only miss 2 days, they're not eligible for TTD benefits, and it remains as a medical-only claim. If it's a medical-only claim and the light duty exceeds 30 days, IRMA assigns a nurse case manager to the file. If the injured worker has significant or ongoing treatment, the case will be transferred to a lost time adjuster as well. And also, questionable medical-only claims are also transferred to a lost time adjuster for additional investigation. Lost time claims. So if an injured worker misses 3 scheduled shifts or more, it is considered a lost time claim, and TTD benefits are due. So in order to calculate the TTD benefits, we require a 52-week wage statement, and the wages must cover 52 weeks preceding the date of injury. So we calculate wages based on the previous year. All nurse case managers are assigned to lost time cases, and IRMA encourages light duty. As Margot said, we can't tell you how important it is to get an injured worker back to light duty as soon as possible. So we encourage light duty, and keep in mind that light duty does not have to be limited to the department that they're employed in. Light duty can be anywhere within the member, the city, the village, anywhere. So it's not limited to the department. And we recommend ongoing communication with the injured worker, be it a supervisor, a manager, or even a claims coordinator. We've discovered that if an injured worker feels that an employee is concerned about them post-injury, it actually goes a long way. When speaking with injured workers, they sometimes voice how no one from the employer called to check on them and to see how they're doing, especially post-surgery. So I just think a phone call and to pick up the phone to see how you're doing, how the injured worker is doing, will go a long way. And I'm going to turn it over to Mike so he can explain the forms.
Hello, I'm Mike Metzger. I'm going to talk about workers' compensation forms. You each have a packet in the back of your folders that says Workers' Compensation Informational Packet. These are the forms that I'm going to talk about today. The Employer's First Report of Injury form, which is page 1 of your packet. This is a form that's required by the state of Illinois, so this form must be completed on all workers' compensation claims. If it's a lost time claim, when we get this form, we send it into the state because they do keep track of lost time claims. You do not have to submit it to the state yourself. It's very important to fill this form out as completely as possible. Some of the more important information is we definitely need the birth date of the injured employee, and we definitely need the home address. We often get the village's address on our forms, and whenever we get that, I have to call the village and get their home address, because we do send them correspondence. Even for our medical-only claims, we send out an acknowledgement letter, so we need to know the employee's home address. Some of the other important things are date of injury, when did the accident happen, the time of day, did it happen on your premises. Most of this form is self-explanatory. Please complete this form as best you can and as completely as you can. but don't hold it up if you're waiting for just a couple of pieces of information. Please complete it and get it onto your claims coordinator, because we want to get the report of injury as soon as possible. Sometimes you don't have every bit of information, and we prefer to start investigating the claim as soon as possible. So please get everything that you know, complete it, and send it to your claims coordinator to submit to IRMA as soon as possible. The next form, which is page 2 of your packet, is the supervisor's investigation report. Now, this form, along with the employer's first report of injury form, are the forms that we require for the setup of a workers' compensation claim. This form has some important information on it as well, and I'm just going to point out a few things. The Social Security number. Unfortunately, we still need that for workers' compensation. We do report the claims to Medicare. We're required to do Medicare reporting, so we do need the entire Social Security number of the injured worker. Some other things that are important is, did the injured worker miss more than 3 days from work, or 3 scheduled work shifts? We need to know that, because if they miss more than 3 days, that's a lost time claim. So that affects us right out of the gate as to who I'm going to assign that claim to. So we want to know if they're missing time from work. Some other important information on that form is witness information. Please complete any witnesses on this form. And also, if you can, please have the witnesses complete a written statement. That would be very beneficial as well, which is another form. And at the very bottom, this is very important for our risk management department and also for your safety committees. How could the injury or illness have been prevented? We always look at that, or I always look at that when I assign a claim, and there's a remedy below that, and the supervisor will generally fill in how this could have been prevented. Now, if we see something that looks dangerous, like a dangerous condition, I may in turn send that to Dan Letourneau in our risk management department, and you may get a call from him, simply because we're trying to avoid that accident happening again. So there have been cases that we've seen where our risk management person comes out and we redesign the work procedure. For instance, we've had some lifting claims where somebody's been lifting something and we've found that there's been a different way to perform that procedure. Maybe it's additional help, maybe it's some type of lifting device, but it is very important for you to examine this with your safety committees to try to avoid future losses. Employee statement of incident. This is page 3 of your forms. This is important to have the injured employee fill out this form as soon as possible. Now, I know in all cases they may not be able to do this, but whenever you can have them fill it out, it's very beneficial to us. And the reason it's beneficial is because it's always good to get the story right after it happens, the version of the incident, because you wouldn't believe over time how stories change. I mean, we have people that mention they've hurt one part of the body, and 6 months later they're talking about an entirely different part of the body. So we like to pin them down to a specific part of the body. As you see, there's a body chart on here, and we ask them to circle the parts of the body that are injured, just so we don't have that circumstance where 6 months from now or a year from now, they started with a knee injury and now they're talking about their shoulder 6 months from now. So this is a great form for them to fill out. Also, it mentions if they've had any complaints to the same part of the body in the past. That's useful information to us as well. The next form is the authorization for medical records and communication release. This is page 4 of your packet. We appreciate it when the member can have the injured worker sign this form following their injury, but I understand in some cases that may not be possible, and we still send this form out to the injured worker as well. So if they don't fill it out there, we will also be sending them this form. This helps us get medical records. If they sign it after the injury, it just might help us get the records a little bit quicker than if we have to wait to get it by mail. And the next form, which is page 5 of your packet, is the witness statement form. This can be used both on workers' compensation and liability claims. It's good to have any witness to the injury complete this form after the injury happens. And they might not even witness exactly what happened. They might be at the scene after it happened and describe the details of the scene. For example, if you have a wet floor and somebody slips and falls on that floor, we would like to get photos of that floor. But it also helps us to get somebody describing the accident scene. So they can say, yes, the floor was wet following the accident, or no, the floor was dry, there was nothing wrong with the floor at the time of the accident. It's good to get that information as soon as possible because, again, stories change over time, and that's fresh in their memory right following the injury. The next form is page 6 of your packet. This is the incident first aid report. When you have an injury and the injured worker doesn't require treatment, you don't need to submit a claim to IRMA. That is not a claim, that's an incident. Now you can submit an incident to us and we'll keep a record of it, but it's not required. But the important thing is that if you have an incident, somebody injures themselves at work and they don't require treatment, please keep an internal record of everything that happened regarding that incident. This is very important because often someone will come back a week or two later and they will be having pain from maybe they strained their back, they thought it was okay, it got worse over time. If you don't have a record of this, then you don't know it happened or you don't have all the details as they were right after the event. And often people will come in 3 months, 6 months, and sometimes even a year later and talk about an injury they had 6 months ago, and it's very difficult to reconstruct that if you didn't keep any information about what happens. So I would encourage you to get the exact same details if you have an incident as if you have a claim, just so you have that information available. The next form I want to talk about is the medical report form, duty status report. This is to be completed after every doctor appointment. If your occupational clinic has one of these forms, it's not necessary to use this form. But this form is very comprehensive in terms of getting someone back to light duty. It basically says how much lifting they can do, what if they can sit, stoop, kneel. It gives a good description of a light duty job description, and that's what we want to do. We want to get people back to light or full duty as soon as possible. This is a really good form to send to with the injured worker to their own doctor if they go treat with their own doctor, because from their own doctor, we don't often get the information that we'd like to get. So this is a great form to have their own doctor complete and return to the employer. The injured first fill prescription form, that's page 8 of your packet. This is a form that's for the benefit of the injured employee. When they get hurt at work, you can give them this form and they can take this to the pharmacy and get their first prescription filled with no out-of-pocket cost. So this is beneficial for the injured worker because that first pharmacy prescription can be expensive sometimes. And the next form is the workers' compensation wage statement. That's page 9 of your packet. Not everybody will see this form, but this is the form when we're talking about the average weekly wage of the employer. We need to go back 52 weeks from the date of the injury and average out their wage for that 52-week period. So we have to have this form completed when they're going to be missing more than 3 scheduled work days. All of these forms are located on the IRMA website, which I believe you might have something like that in your packet as well. But you can look up all of our forms, and there's also some great information on there on risk management and training, and it's just a really good resource for you. Now I'm going to talk a little bit about investigation of the claim. If you refer to your packet, there's a laminated form in your packet. This was designed, it's called the Member Internal WC Investigation Guidelines. Just gives you some of the questions that we would be asking when we complete our investigations and gives you some good information internally to look for. First thing is, when did the injury occur? I mean, did it happen during their regular work shift? Or did it happen on their lunch break? Did it happen after work? Did it happen before work? All of this is important to us when we're investigating to determine whether it's a compensable claim. Who was it reported to? We always look at when it was reported and who it was reported to. As Melissa mentioned earlier, in workers' compensation, they have 45 days to report the injury. If they don't report it within 45 days, we may have a basis for denial of that claim. So on your form, on one of the forms, it actually indicates, I think it's the supervisor's investigation report, who it was reported to and when it was reported. That's something we will always look for. Where did the injury occur? Did it happen on the member premises? Did it happen off premises? Did it happen in an area that's accessible to the general public if it happened on premises? Was there anything defective in the area? Was there anything wet? Was the floor wet? Was there anything on the floor maybe that caused somebody to slip and fall on the floor? Very important to look exactly where it happened, because it's hard for us to go back later again if it happens somewhere like in a parking lot and you don't take pictures of where that happened and you don't make comments as to what the condition was of where that happened. It's going to be difficult for us to exactly tell where that accident took place. And it's very important because I can't tell you, we get a number of claims where there's no pictures and nobody looked at the accident scene right after it happened. So we're taking a guess when somebody slips on some stairs and falls and it's out somewhere. We don't know what happened if you don't take pictures of the incident, and if nobody follows out to check out the condition of what the steps were like or what the parking lot was like where somebody fell. And then what caused the injury? What was the employee doing at the time of the injury? If they slipped or tripped, what caused them to slip or trip? If they were lifting something, what were they lifting? What did it weigh? Was there a third party involved? That's important because we want to look for potential subrogation. So if another party was responsible, we want to look into that. For example, sometimes we have claims where somebody slips and falls on your premises and we have a cleaning contractor that comes in and cleans your premises and they've left the floor wet in a certain area and they haven't put up signs. We have, I think, 2 cases going on like that right now. So what we will probably do is we'd like pictures of that, and we'd like to know where the signs were posted, if there were any signs posted that the floor was wet, or we'd like to know if there were no signs posted, because we might have a potential subrogation claim against your cleaning contractor. What we will do is request a copy of the contract between the village and the cleaning contractor, and we will have to investigate if indeed they caused the injury and if they took the proper safety precautions so that it shouldn't have happened. If they have the proper signage up, then we probably don't have a third party case, but if they don't have the proper signage up, we may have potential subrogation on that claim. Preserving evidence. Please take photos of the location of the incident. I mentioned this earlier. It's very important to take photos of where the incident happened. Please obtain written statements from witnesses. Again, this is important even if they didn't actually witness it. Sometimes the details of where the fall happened or where the injury happened are also important. So just what they reported to that coworker that was by them, what happened. They might not have actually seen it, but their written statement as to what they told them would be important to us. Secure any video surveillance footage. We have several injuries for workers' compensation that we actually have on videotape, which is great. A lot of the members have video surveillance, and we've actually captured some, on tape. And it's good from both point of views. It's good to show that something did happen as required or that it didn't happen as reported. So we want to know either way what happened. So this is a good tool. There was actually a case in Florida, which I couldn't get the video clip of, where an injured worker, a sprinkler fell from the ceiling. This was a fraud case in the state of Florida. And they looked around and they picked it up and they slammed it into their head. And they had it on videotape. So that was actually a fraud conviction in the state of Florida. Now, you're probably not going to see that very often, but that you could see somebody possibly exaggerating what they're telling you, though. So retain any defective products. We have a case that we recovered money on where a chair collapsed on somebody. We needed to keep that chair because we had to have an expert look at that chair and examine it. And we did recover money on that case. That's a common one, but it might also be something that you don't think of, like maybe a defective tool. Anything that's defective, make sure you keep that product until we have a chance to check it out, see if there's any potential subrogation. Workers' compensation compensability. When we talk about compensability of a case in workers' compensation, we're basically talking about whether we're going to accept that case under the Workers' Compensation Act. There are 3 components of compensability that we look at. Did the injury occur within the course and scope of the duty, or course and scope of the employment? For example, the best example of this is if somebody's engaged in horseplay, like say you have 2 public works workers and they decide they're going to race back to the truck for a non-work related reason, and one of them injures their knee racing back to the truck. That's horseplay. That's probably not going to be accepted under workers' compensation because it has nothing to do with their job duties. So that would not be within the course and scope of their duty. You must be at a greater risk than the general public. For example, if you're walking across the floor, there's nothing on the floor, and all of a sudden your leg gives out, your knee gives out, and you fall. That really has nothing to do with work. You're not at a greater risk than the general public, so that would probably not be compensable under workers' compensation. Some other examples might be you're getting out of a car, a normal vehicle, a normal car, normal height off the ground, and you injure your back. That would probably be a questionable claim and maybe a denied claim under workers' compensation. However, we also have claims where the members are getting out of trucks that are much higher off the ground than a regular car or pickup truck. Those are compensable claims because they are at a greater risk when they're getting down from a higher vehicle than the general public would get down from. And that is actually most of our claims that we see when somebody gets injured getting out of a vehicle is because it is a vehicle that's higher off the ground than a typical vehicle. Medical condition causally related to injury. We have to make sure that the medical condition is causally related to work. A good example of this might be a carpal tunnel claim. When we get carpal tunnel claims in for someone that is just typing at work, we always question those claims. We get all the medical records. There have been studies that show that carpal tunnel is not related to typing. So when we get those in, we request all the medical records, and we make sure that there's even a history given by the doctor that says this is related to work. If it is related to work, according to the treating doctor, we will probably get an independent medical exam on that case to get an opinion as to whether their job duties could have caused carpal tunnel. What we do is we get a detailed job description from the employer. We find out excuse me, how much time they were typing a day and how much time they were doing other activities. There are some people that aren't even typing all day that are filing workers' compensation claims, and they have various job duties. So that even makes a stronger case for us that they're not doing something repetitive all day. On the other hand, where we see something that's a forceful motion, like somebody perhaps is a mechanic or something and they're doing forceful repetitive motion, that has a much better chance of being a compensable workers' compensation claim, because forceful repetitive movement is what is supposed to cause workers' compensation, or is supposed to cause carpal tunnel claims. Questionable claims. A questionable claim is really something that you know about at the member, and we won't know that until you tell us. An example might be you know somebody that has a pre-existing back condition, and you know that they have ongoing treatment, and then they claim a back injury at work. Well, we would like to know that just because we want to see if they actually had an ongoing condition for which they were treating before the injury occurred. Now, you can have a pre-existing condition and have a new work injury. The only way this might apply is if you are actually treating for that same condition. That's where we can actually possibly get a medical opinion as to whether your condition is related to the injury or whether it's a pre-existing condition. Another case might be the questionable is you hear that somebody is out playing basketball over the weekend and that they injured their knee. They come into work Monday morning and they're there for about an hour and they report that they injured their knee at work. We would like to know that information because we want to check out with any witnesses that saw them injure themselves or knew that they injured themselves playing basketball over the weekend. And anything we can do to verify that would be helpful to us. And another case might be just somebody that is off work and you know that they're engaged in activities that are greatly exceeding what they should be doing. For instance, we have people that we get a tip from the member that somebody's moving furniture over the weekend and they have a severe back injury. We might assign surveillance on that case if we get a tip from you that they are going to be moving over that weekend. We've had people that have worked other jobs while they're off on workers' compensation. We definitely want to know that. If you feel that they might be working at another employer or doing some work on their own, please let us know so we can check into that, and we often schedule surveillance on those types of claims. And now we have a case study that Melissa Hurd is going to present to you.
And so quickly, I have a case study that I want to go over with you guys. This is actually a Irma case wherein She was walking from her personal vehicle. A records clerk slipped and fell on an icy sidewalk leading to the parking lot. We performed an investigation. The parking lot and the sidewalk was open to the general public, and there were no designated parking spots for the employee. We denied the case, and the reason why is because the accident did not arise out of her employment, and she was at no greater risk or an increased risk than the general public as a result of her employment. It went to trial. The case became litigated and went to trial, and the arbitrator sided with IRMA and agreed that the employee was not directed to park in the lot, and she was not at an increased risk. And so it's very important when we get a lot of slip and fall cases, so it's very important that you get all the details surrounding the slip and fall, whether the lot was open to the general public, if they're designated to park there, were they rushing, were they carrying work equipment, were they going to lunch, were they coming in. So it's very important that you gather those details, because the details makes a really big difference on whether or not we deny the claim, and we often get these claims. So it's very important that you give us the information that we need to make a determination. And I'm turning it back over to Mike.
Okay, and this is another case, first I'm going to talk about medical causation. Occasionally there are questions surrounding the medical causation of an injured employee regarding a particular diagnosis, a recommended procedure, or a current work status. This may be addressed by a third-party expert through an independent medical examination, which we often refer to as an IME, or a utilization review, which we often shorten as UR. An independent medical examination is not scheduled on every claim. It's usually scheduled if we have a few situations mentioned above here. If we have a question, if someone has if their condition is medically related to their injury, we might schedule an IME. For example, we do know somebody had ongoing treatment before the injury. We might want to get all their past medical records and schedule an IME and ask that doctor, is their current condition a temporary exacerbation? Is this a temporary exacerbation of their pre-existing condition, or is this a new injury? If it's not a new injury and it's a temporary exacerbation, we may deny further treatment on that claim if the doctor feels that no treatment is necessary as a result of this incident. Another example might be we might get an IME because a particular procedure is recommended, which we may question whether it's appropriate. Or probably the most common one is when someone is just not progressing. They're in physical therapy, they've been treating for a long time, and they're just not meeting what we call the ODG guidelines, which are the official disability guidelines. If they're not getting any better, often if they're in physical therapy or chiropractic treatment, we'll request utilization review, which will comment as to whether further treatment is approved. And then we may also, in conjunction with that, schedule an IME to find out from the doctor what treatment is necessary to get that injured worker back to work. When we get an IME, we send it to the treating doctor, and we try to get the treating doctor to implement that plan, that treatment plan. They don't always accept that treatment plan, but that is our goal, is to get them to work with the IME doctor and to get that treatment plan in place and get that injured worker back to work as soon as possible. Utilization review, we don't have to have an IME in conjunction with that. That may just be because, for instance, with chiropractic treatment, we know that after 12 visits, generally someone doesn't keep progressing after 12 visits, so we probably will request utilization review for chiropractic treatment if it exceeds 12 visits. For physical therapy, if someone's not improving in physical therapy, we don't want them to continue physical therapy because it could be quite possible that they need some other form of treatment, and they're not going to progress in physical therapy if they're not improved after a certain point in time. So that might be a time where we also get an IME to see what type of treatment is necessary if we can't get their treating doctor to move on to a different type of treatment. Okay, here's a case study for medical causation. This is an actual IRMA case. A water department maintenance worker was checking the property for a possible leak. He was walking on wet, muddy boards when he slipped, twisted his back, and L5-S1 lumbar fusion was recommended. Okay, the investigation There was an indication of prior back injury when the case initially started, but we didn't have a lot of records, but we had some to show that he had some pre-existing history. We ordered an IME or scheduled an IME, and the prior medical records were requested. The initial IME results, with the records that we had at that time, the injured worker denied a history of significant back problems to the IME physician, and the doctor opined that the claimant aggravated his pre-existing condition to the point where that injured worker needed surgery. Okay, all the previous medical records weren't available at that time. They were still coming in. And at that time, we really had no reason other than our suspicion that we should deny that claim. So we started benefits on this claim. But when we saw some additional records came in, we sent those to the IME doctor and had an addendum report completed. And he looked at that. The previous records indicated that the injured worker was symptomatic before this accident. The doctor opined in the addendum report that the incident caused a minor exacerbation, and the ongoing symptoms the patient had were related to a natural progression of a personal health condition of the lower back and not a work event. The IME doctor was actually really aggravated when he saw the additional records, because the patient, when he was in there, said he had really no back problems at all, and he had really serious back problems, and we just didn't have all the records at the time. But when we came up with them, and when we got them, the IME doctor was a great witness on this case, because he was really aggravated that the claimant had lied to him about his pre-existing condition. And this claim was denied. Why? It was based on the expert opinion of the medical physician that the need for surgery was not causally related to the work event. The result, the denial was disputed and it went to trial. The arbitrator agreed with IRMA's decision to deny based on the medical records and the expert opinion. IRMA had a savings of at least $1.5 million. We had significant medical, and this gentleman never went back to work, in future claims costs for surgery, TTD, and PPD. And this particular worker is still paying us back $100 a month for the money that we did pay him when we thought the claim was originally compensable. So we are getting payments which he will have to pay to us for the next 20 years if we're going to get it all back. But often we take what we can get when we're getting money back from someone when we pay it in a case like that. I'll talk a little bit about rebuttable presumption for firefighters and paramedics. Section 6F of the Illinois Workers' Compensation Act expands workers' compensation coverage for firefighters and paramedics. However, all the factors below must be present. The statute applies to all cases involving firefighters, emergency technicians, and paramedics. The statute applies to an employee who has been employed as a firefighter, EMT, or paramedic for more than 5 years at the time he or she files an application. The case involves any injury or condition or impairment of health which is directly or indirectly from any of these conditions. Any bloodborne pathogen, any lung or respiratory disease condition, any heart or vascular disease, any hypertension, tuberculosis, cancer, hernia, and hearing loss. Now, what this means is that when a firefighter has one of these conditions, it's presumed to be related to their work activities. But we have the right to rebut that, and we often do. Particularly, I would say the largest amount of cases that we received that we didn't receive before this act are cancer claims for firefighters. We have a number of them on the books right now that we're defending. And in most of these cases, we will get all of the records from the firefighters' calls that they attended. I know that's difficult because sometimes the firefighters can't produce all the calls they've attended over the years, but most of our villages do a good job of providing that information. We particularly want to know what calls they might have been exposed to hazardous chemicals at. We take that information we get all of their past medical records. We look for things like family history of cancer, whether the person was a smoker, which in some cases they are, and we send all that information for a medical records review and have the doctor examine that to determine whether the cancer condition is related to their work activities as a firefighter. We've only had one case go to trial so far, and that was for prostate cancer. We lost in front of the arbitrator, and the decision was reversed at the commission, and no benefits were awarded. That case is still being appealed by the claimant attorney. We have a number of other cases that probably will be heading to trial at some point. The strange thing is that most of these cases aren't lung cancer cases, which is probably what you would expect for firefighters, but we get a lot of prostate cancers and various other forms of cancer. And in some of the reports that we get, they have a family history and they're predisposed to having this type of condition. And there's a lot of factors that play into it, but this is a situation where we will get an opinion on medical causation. So this is a good example of using a medical opinion for medical causation to determine if the condition is related to work. Workers' compensation denials. There's two types of denials. We deny a claim sometimes in its entirety because it's not a compensable case or the injury is not causally related to work. We may deny the entire case. The other type of denial is we accept the claim and we deny some type of treatment. For example, they might have a surgery which isn't appropriate, or we've got medical evidence that it's not appropriate. We may accept that they had an exacerbation of a pre-existing condition, but not that the surgery that they had is related to this injury or caused necessary as a result of the injury. So these are the two types of denials that we have. There are several steps an employer can take to prevent delays in treatment. The problem that we see with denials, of whether it's denying an entire claim or denying treatment, is there sometimes is a delay on the injured worker getting the necessary treatment to get better and get back to work. There may even be a delay when we're requesting medical records from the injured worker. If we know somebody has a pre-existing condition, we're going to want to get all of the medical records, all of their previous medical records. It takes us some time to get that information. So what we do is we recommend to the injured employer or the injured worker is that they submit their treatment to group and move on with their treatment, because if they need a surgery or they need some type of treatment, they should not hold it up waiting for a decision on their workers' compensation case. And we will encourage them to turn that into their group of carrier and go ahead with the procedure that they need. Some things that the employer can do to prevent the delays: impose FMLA from the start of an injury. If you look in your forms packet, if you look at page 12, there's a sample FMLA letter that was actually written by Margot. And this is a letter that you can use, and you can also might want to take it to your labor attorney and make sure that this fits your needs. But it's good to impose FMLA from the start of the injury. The second point is remind an employee he or she needs to treat diligently to return to work at his or her position, and that his or her position may not be kept open indefinitely. We have claims that go on for months and years, and it's very difficult for our members when they have somebody that's been out of work for a significant period of time. What happens on some of these cases is we get an IME and we have a dispute on some of the cases. We're not going to pay for the case because we don't think we should be paying for it. The injured employee wants to get the bills paid. They're going to pursue the case through the workers' compensation system, which is how they should pursue the case. The problem is we don't want them to stop treating during that period of time. We want them to continue their treatment. So if we see a case like this, we will often recommend a conference call with the member and possibly their labor attorney to discuss this type of issue, because our goal is for them to continue to treat and get back to work as soon as possible. And that's their duty to you as an employer, to do whatever they need to do to get back to work as soon as possible. We have a sample letter on page 13, which is a letter regarding their duty to treat and that you can't hold the position open forever. We would encourage you to get your labor attorney involved in these conference calls too, and we do these all the time. This situation is a very common situation, so please feel free to reach out to us for help if you see this type of condition going on. We try to note it ourselves, but if we overlook it, please bring it to our attention. Workers' compensation fraud and surveillance. I have a couple of clips here that I was going to show you. Okay, this is an injury, a right hand, right wrist and elbow injury. This is actually an IRMA claim where we discovered, this is a police officer, where we discovered that he actually was a personal trainer while he had his wrist injury. And you can see that's him doing the chin-ups in the back, and he had restrictions for his wrist. And he was a personal trainer. He was lifting weights. He was doing chin-ups. This gentleman was actually convicted of fraud. So this is probably the best surveillance we ever got on anybody. But so of course I'm going to play that one for you. But surveillance is an important tool on some cases. It's not good for every case. The good surveillance is normally when we get a good tip on what the injured worker is doing. Like if you know that somebody's active, if they're a weightlifter, for example, which they knew in this case, and they knew where they might be working out, we ran surveillance, and that makes it very easy for us to find something in some cases. But if we're just taking a shot in the dark and following someone around, we don't often find them doing something that's above their work restriction. So it's much better if you can provide us a tip. A good way to get tips is if anybody at the village is a friend of the injured worker on Facebook. We often run social media checks on people to see if they're involved in any activity posted on their Facebook page, but we're not a friend to their site. So if you know somebody that's a friend with them on Facebook, you might be able to get some information that we can use for surveillance or just general tips. Okay, this is a tip provided. This was a shoulder injury. This is not an IRMA claim. This is not an IRMA claim. This is just an example of a case that I don't know if it's a fraud case, but it's an example of somebody greatly exaggerating their work restrictions or that they should be off work. So again, this is not an IRMA claim, just a funny example of a case where somebody's clearly in violation of their work restrictions. So the best that you could do, again, is provide tips to us as to when somebody's active so we get good surveillance. Now, fraud is a difficult thing. Fraud is a difficult thing to prove even if we have good surveillance. So some of the one case we have convicted of fraud that involved good surveillance. We have another ongoing case right now where we did a biomechanical analysis. Somebody was involved in a very minor impact auto injury, and we did a biomechanical analysis, and the analysis stated that there's no way this person could have torn their rotator cuff or their shoulder from the impact that the vehicle had. That is actually an ongoing fraud investigation that we have going on right now. We also have, as an example of good surveillance, we have one for IRMA that's a case where we caught somebody using a sledgehammer repeatedly, and they have a shoulder condition. That is still an active case, so I'm not showing the surveillance on that, but that's still an active case from IRMA, where somebody was using a sledgehammer very vigorously, and they claimed that at one point they claimed they couldn't work at all, and now they claim they're still having problems with their shoulder. So we can get good surveillance. It doesn't always result in fraud. We can use biomechanical analysis occasionally, but it has to be for the perfect type of case. We had a case in we had a case in the past where somebody fell out of the back of an ambulance. This is a right knee ankle injury. Somebody fell out of the back of an ambulance, and the member said to us, there's no way this employee could have landed the way that they said they landed out of the ambulance. Well, we did a biomechanical analysis, and it was proven right that they said there is no way he could have landed, or she could have landed that way, and we denied that claim as well. So if you ever have a suspicion about a claim, I guess my message is bring it to our attention, and we'll do whatever we can to investigate that claim and look into any possible fraud or exaggeration of their claim. So again, this is a wrestler with a knee injury. Okay, so I'll move on after he does this jump. Okay, and now I'm going to turn it back over to Melissa to talk about defined workers' compensation benefits.
Sorry, I don't have any more funny videos. So during this presentation, we're going to talk about the benefits that are involved with the workers' compensation claim. Excuse me, the medical, the TTD, the TPD, the permanent partial disability, the vocational rehabilitation, the wage differential benefits, and death benefits. Medical treatment. So we'll get started with the medical treatment. And as a reminder, we ask that you do not make compensability decisions. That should be left to the IRMA staff, and we ask that you do not authorize treatment for obvious reasons. But one of the reasons why that we ask that we like to speak with the injured worker and discuss if the doctor is recommending diagnostics. We have a diagnostics, a network that we utilize, and they perform the MRIs, CT scans, and arthrograms. And we also utilize a physical therapy network, and we get a significant savings when the injured worker utilizes these providers. Although we can't direct care, we can provide them with options. And so we give them the options to treat or to go to our network so that IRMA sees a significant savings. And the turnaround time is pretty good for MRIs, arthrograms, CT scan. The turnaround time is normally 24 to 72 hours, so we can get you in we can get the injured worker in right away and get a report within 24 to 72 hours. Medical management and treatment. So we're going to talk about the physician choices, the nurse case management, the light duty and early return to work, and IMEs, utilization, and medical bill review. So the medical management, that's your occupational health clinic. And so whenever possible, an injured worker should always go to the occupational clinic, especially for the minor bumps and bruises, the sprains, the strains. We recommend that they go to the occupational health clinic as opposed to going, of course, to an emergency room. But of course, if there's an emergency or an urgent issue, then they should always go to the nearest emergency room. And the benefits of the occupational health is that the staff has more expertise with occupational injuries. They have a strong return to work philosophy, so they realize that when an injured worker says, no, we don't have light duty work available, we provide them with a job description and we notify them that yes, there is light duty work available. So they're aware of that, and they have a strong, they emphasize return to work, light duty, modified duty. And also if there is a need for a referral to a specialist, they'll get, normally they'll get the injured worker in right away to a specialist, and so time isn't wasted in regards to the treatment. The choice of physicians. Now the injured worker has two choices of a physician and any referrals. So for example, excuse me, if an occupational health doctor refers a patient, instructs a patient to go to a hand specialist, and he goes to see that hand specialist, and the hand specialist refers him to another doctor, that remains one choice by the employee. So any referrals is considered still one choice. After the injured worker has exhausted his two choices, then he's responsible for payment of additional doctors thereafter. And so the benefits of a nurse case manager. The nurse case managers assist with the medical portion of the file, and we have found that they are really pertinent when it comes to getting the injured worker back to work, communicating with the doctor and all the providers, with physical therapy. They have the medical expertise to effectively communicate with the physicians, and they provide assistance to the injured worker as well. It reduces the medical cost on the claim, and they help to avoid unnecessary treatment. Oftentimes we look for the nurse case managers to give us opinions on what they think is appropriate and what they think is excessive. So they're an asset to the claim. It also reduces the indemnity costs by getting the injured worker back to work sooner. And we utilize 2 nurse case management firms that we refer our cases to, Eagle One Case Management Solutions and Custom Case Management. Modified duty and light duty. And throughout the presentation, we can't emphasize enough how important that is. IRMA strongly encourages light duty. I know a lot of times the firefighters, with the union and with their contracts, they don't have a modified duty or light duty, but whenever possible, we encourage that. And again, keep in mind that it does not have to be in the same department. It can be anywhere within the village or the city. The modified duty increases the morale of the injured employee. It increases the productivity in the workplace. There's definitely a cost savings when it comes to TTD and the settlement, and there's an incentive to return to work regular duty. And the medical bill review. So all of our bills are submitted through our bill review company, which is Corvell. And they're submitted to make sure that all the treatment is appropriate and necessary. We often get bills where the injured worker, his injury is to the knee, and we get bills for the back or for the ankle. And so Corvell does a very good job in separating and weaning out the unnecessary treatment that's not covered, that should not be covered. And we've saved $6.5 million in 2006 as a result of medical bill review and the Illinois fee schedule. So we do send all of our bills, and here's the address to where the bill should go, and that's also included in your packet. Time off work, TTD and TPD. So as I stated before, temporary total disability, that's TTD benefits, and that's when an injured worker is off more than 14 days, misses more than 3 days. So TTD is 66 2/3 of the gross average weekly wage. And so again, a wage statement is needed to calculate the benefits for that. If the injured worker is off less than 14 days, there's a 3-day waiting period that they're not eligible for TTD. So if they're off 12 days, the first 3 days, they are not paid for under the workers' compensation statute. However, if they're off more than 14 days, they get paid for the entire time. And yeah, it goes back from day one. And temporary partial disability benefits, that's for employees who work part-time and they're earning less than what they were previously, and they're entitled to temporary partial disability benefits. And again, it's part-time where they're earning less. And that's 2/3 of the difference. We pay 2/3 of the difference between what they were earning at the time and what they're earning now. And unless otherwise stated, all of the TTD and the TPD checks go directly to the member, unless otherwise stated. Also, if an injured worker has secondary employment, they may be entitled to wage loss for the secondary job. The member has to be aware of the secondary employment in order for them to get compensated for that time. So if you're not aware that they have a second job, they are not eligible for the wage loss for the secondary, for their second employer. And we'll have to get a wage statement. Once we confirm that the member is aware, we get a wage statement. We get the contact information from the injured worker for their secondary employer, and they provide us with a wage statement as well. And those wages go directly to the claimant's address. The secondary wages do not go to the member. The member is not involved in that, and so they go directly to the injured worker. And I'm turning it over to Mike for the settlements and resolutions.
And I'm going to talk about workers' compensation settlements and solutions. If you go to page 14 of your packet and page 15 of your packet, I have a couple of charts in there which have, on page 14 it has that each part of the body is worth a certain number of weeks of permanent partial disability. and has a schedule of those injuries. On page 15, it has the maximum rates for this period in time for both TTD and PPD. When somebody's talking about a settlement in workers' compensation, most of the time they're talking about a permanent partial disability settlement, which is referred to as PPD. How that is calculated is we take the part of the body that was injured. For example, if you injure your knee, that's considered part of the leg. We would look and we see that the leg is worth 215 weeks of permanent partial disability. We take a percentage of that, and we get that percentage based on what these cases typically go for a particular type of surgery, a particular type of recovery. There's usually a range of values for these cases. So let's say, to make an easy example, let's say we offer 10% of the leg for a knee surgery. How we calculate the settlement is we take 10% of 215 weeks, and we have 21.5 weeks, and we take that times our permanent partial disability rate. Now, the permanent partial disability rate is 60% of the average weekly wage, up to the maximum rate, which right now is $775.18. So if you took 21.5 weeks times $775.18, you would have a settlement of $16,666.37. That's just an example of how a permanent partial disability settlement works. Now, if somebody injures their back or their neck, that's considered part of the body as a whole. The body as a whole is worth a total of 500 weeks of permanent partial disability. So if we did 10%, say, on a back injury, we'd be talking about 50 weeks of permanent partial disability. Just an example of how it works. Now, on certain parts of the body, we're allowed to take a credit. If somebody had a previous knee injury and they had a settlement for 15% of the knee or of the leg, for example, and now they had, say, an ACL repair, say we're going to offer 20%. We think the case is worth 20% of the leg. We take a credit of 15% for that previous settlement, so we would only offer them 5% on that case. Unfortunately, there is no credit for the body as a whole, which is our larger claims for the back and the neck. So people can theoretically go back and re-injure themselves and still get another large settlement, because we can't take a credit, even though we will bring it up as part of the negotiations that they had a pre-existing condition. The shoulder now used to be considered part of the arm, but there's been case law where now it's considered part of the body, so we also don't get a credit for that. That's considered part of the body as a whole. The other type of settlements we see in workers' compensation are wage differential, or our wage differential awards. If somebody can't return to work, they have permanent restrictions as a result of their injury, and we always encourage you to bring them back to work if you can, but in a lot of cases you can't bring them back to work because their job duties are so physical that you don't have a position for them. If you can't bring them back to work, we will probably need to send them to vocational rehabilitation, which is a service that we use, which a counselor that tries to place that injured worker in a job within their restrictions, taking into consideration their job skills and their experience in the past. Our goal is to get them the best possible job, because the wage differential component is figured on, is calculated based on what rate of pay they get. So if we have to offer some minor retraining, we will also do that. In some cases, we might offer more than minor retraining, depending on the circumstances of the case. But let's just say they get a job. They were making $1,500 a week at the member. That was their average weekly wage. They go through vocational rehabilitation. They only get a job making $600 a week. And I will tell you, vocational rehabilitation, we don't get great results. I mean, usually the average of the people we place is about $10 to $12 an hour. So this is pretty realistic, the $600 a week. Well, how we figure the wage differential is we take $1,500 that they previously made and the $600 that they're making now. We take the difference of that, which is $900, and they get 2/3 of the difference. So they would get $600 per week, and they're eligible for that until age 67. As you can see, that amounts to a lot of money. I did some calculations, and in 1 year that was over $30,000. In 10 years, it was over $300,000. often these injured workers are even younger than 57 when this happens, so it's going to be even a larger amount of money, and often they don't get a job making $600 a week, they get a job making $400 a week. So these could be very large cases. And once there's an award on these cases, we can't go back in and get this changed. They can go out and get another job making more money, and we can't take that back into court and get an adjustment on that case. So we try to settle these cases on a lump sum basis whenever possible, because we choose, if possible, not to pay their benefits over the next 20 years. How we do that is we look at the present value of what that case is worth over time, and we try to settle that based on a percentage of that present value. These cases are very expensive cases. It's usually common to see them in the range of $300,000 on a lot of our cases, because they are younger people sometimes and they don't always get very good jobs. Another type of a case that we pay PPD on is a public safety career-ending injury. When someone is a full-time firefighter or a police officer, they're usually eligible for a duty disability pension. That removes them from being eligible for a permanent total disability or a wage differential case. They can't get both because there's an offset. So they want to settle their case based on permanent partial disability. These cases typically go for about 40% of the body as a whole. If you remember, the body as a whole is worth 500 weeks of compensation, so 40% of the body as a whole is 200 weeks, and we take that times their rate. A lot of our people are at the max rate, which is right now $775.18, and a lot of these cases end up being around $150,000 to $160,000 for the settlements. Sometimes they're a little bit more, sometimes they're a little bit less, depending on their wages. Pension applications for duty, non-duty disability. Coordinate the pension and workers' compensation claims. We like to work with you as closely as we possibly can on these types of cases. So please immediately notify your IRMA claims representative if there are pension board hearings coming up on your public safety employees. Again, this would be for firefighters, police that are eligible for pensions. Conference calls are initiated to discuss how workers' compensation and pension claims impact each other. We have a lot of conference calls on these cases. These are big dollar cases for the members because if they were responding to an emergency, or the injured worker is also eligible for PSEBA benefits, which are health insurance benefits for the rest of their life. And that becomes more expensive to the member than even the workers' comp case and than the workers' comp case in its entirety, because you're paying them for another 20 or 30 years, you're paying for family medical benefits for the employee. So we've worked with some of our members. If the member doesn't have a good case to intervene in, we probably wouldn't encourage it on the pension side. But if they do have a good case to intervene, it might be wise for them to intervene in the pension case and challenge that case, because the member saves a lot of money by challenging that case if they have a good case, you know, to deny. The downside of that is if you don't have a good case to deny on the pension side and you intervene and you lose that case, we're probably going to be stuck with the workers' compensation case. We're going to owe the benefits because the case has already been tried. So you know, you have to consider that when you're looking at your cases, but a lot of our members are choosing to intervene in these cases, and in most cases it's because there is an issue they can defend. We have had some cases where the member has been successful. We've done some global settlements, which includes the workers' compensation case. And as part of those, we've been able to get the village and us together have been able to get the claimants in a few cases to waive their PSEBA benefits as part of a global settlement. So that's very productive for the member. I mean, most cases we do still have the value on a workers' compensation claim, but the member can save a lot of money on those type of cases. So we encourage you to ask us for a conference call. We probably will ask you if you don't ask us to discuss that case, because one case does have an impact on the other. So it's important to keep in close communications. And when we have those conference calls, we usually have the workers' compensation attorney, we have the attorney for the village involved in those calls, we have the village personnel, and we have IRMA's personnel, and sometimes the nurse case manager too if we're talking about the medical status of someone. So we're always open for a conference call. Please keep that in mind. These are complicated cases, and we're always open with working with your labor attorney. We share medical records a lot of the times. We do really whatever we can to get the best result in that case for everybody. Subrogation, recovery and workers' compensation. Now, if someone's not represented by an attorney, we can get 100% back on some cases on subrogation. If a injured worker is represented by an attorney, they automatically get a fee out of that case, the third-party recovery. They get a 25% fee. So the most that we can get back is 75% if they're represented by an attorney. Now, factors that affect potential recovery. This happens every day, and you may have heard of some of these cases, but we get pressured on almost every case to reduce our lien on our workers' compensation. We've paid out an amount. They want us to reduce our lien. We try to avoid that whenever possible, but there may be some situations where we would recommend a reduction of our lien. Some of the cases would be if we don't have clear liability, it's a questionable liability case, it's in the court system. We think if it goes to court, if we don't make some kind of compromise, there's a chance that there might be a zero award and we'll get nothing back on that case. So we might agree to reduce our lien in order to get that case resolved and get some money out of that case. Some cases, unfortunately, have very low policy limits. The mandatory limits are extremely low for auto. So we're not going to get everything back. We can only get 75% back of what they recover. So if they're only going to get, let's see, $30,000 back, we're only going to get 2/3 of that amount, or we'll get 75% of that amount up to the policy limits. If the policy limits are $20,000, no matter how much we've paid, we're only going to get 75% of that amount. The amount of the third-party settlement, if there's a large third-party settlement, we really have no incentive to waive or reduce our lien, so we will probably not consider that unless there are some unusual circumstances. Sometimes when we have a low policy limit or we have questionable liability, we'll talk about getting a dollar contract. If the work comp case is not yet settled, we might reach an agreement where we waive our lien or we reduce our lien in exchange for a dollar contract, which closes out the PPD portion of that claim. So that's something we might also talk to you about in some cases. We try to collect subrogation whenever possible. If you ever know of a third-party involvement in a case, please let us know. I brought up some examples. I mean, the most common thing we see are auto accidents where somebody else is responsible. That's probably our most common case, but we also have product cases, like when I talked about the chair collapsing. And we have probably the most often case we see besides that are slip and fall cases. So those are the ones where it's important to take the photos. If you have any surveillance, keep the surveillance, give that information to us and let us know what happened, and we will also use that for purposes of recovering money on the claim when another party is responsible for that claim. And that's all we have. So I will take some questions if anybody has any questions now. Yeah, what if people refuse to sign the medical release? If we can't get the records, we won't pay the claim. I mean, we have to, in some cases, have records to pay that claim. In most claims, it doesn't make a difference. We're able to get most records just from the provider because it's a workers' compensation case. Usually when the medical records comes into play is when we know that there's other treatment that's going on that we need to get the records for. The question was, is that for to determine if there was a previous injury? Okay. Yes, we want to determine if there was a previous injury in some cases. We might have some information from the member that somebody had injured themselves previously or had a previous back problem. So we want to get all their medical records. We're going to ask them who their primary care physician is. We're going to check the referrals to see who was, when we get those records, what other physicians they might have been referred to. Sometimes we actually run a medical records check where we have a surveillance company run a check to see what pharmacies they've been at, what hospitals they've been at, and we just do a general record search on somebody because we know there's something going on with them and we want to find out what comes back, and then when we get that back, we request all the records from those providers. And it doesn't always amount to anything, but we've been able to deny some claims and have come up with some pretty good medical evidence by doing that. Well, yeah, the medical release is for both, but a lot of times we're able to get the records without the release. But yes, it is for both. If the doctor refuses to give us those records, we do need a medical authorization form. So we do want to get that completed on all claims. And sometimes they won't accept our release, and we actually have to send a HIPAA compliant release, which is it's very complicated looking, so we don't send it out in our typical cases and we only send it out when we have problems getting records. When the doctor insists on a HIPAA compliant release, we have a HIPAA compliant release form that we send out to the worker, and we ask them to sign that and submit it back to us. Anything else?
Also, I want to add that when the injured worker doesn't complete the medical release when it's a questionable claim, then we cannot complete our investigation, and we notify them. If you can't sign the release so that we can get the medical records that we need, then we can't complete our investigation, and so you don't have a claim, because we can't decide whether or not it's compensable or not if you're hindering the investigation. So in those circumstances, we normally get the signed release from the injured worker when we notify them of that.
Because they do want to make their claim, so they will usually give us the medical records release. Good point. Any other questions? Okay, well, thank you very much for your time. We appreciate it.